I'm a lawyer, so apparently we don't have hearts, so I'm speaking from my iPhone. So, yeah, good afternoon, everybody. You know, Tando said my discussion points are going to be a legal opinion, but I think in order to actually have true value, I've decided to speak from a practical and practice experience instead of, giving a legal opinion, because a legal opinion is regurgitating what's already in the laws that people generally don't know. So whenever I speak, I either upset the music executives or I upset the artists. I'm not too sure who I'm upsetting today, but I've got a feeling it might even be my own legal industry that I upset today. So I'm also on shaky grounds. So without, my topic is, can legal frameworks improve the music sector's standard operating procedures, contract management, and disregard for copyright laws, labor and copyright laws? And the question that Tando also asked was, are they even the standard procedures, operating procedures in the music industry? And when we had the conversation yesterday, the takeaway was that there are no standard operating procedures. There are standard provisions in contracts versus actual practice. And when it comes to that, it goes to say that when you do have the contracts in front of you and they do have certain provisions and clauses in them, when as an artist or creative you're trying to make a change to those particular clauses, you get told that this is a standard clause in the agreement instead of saying this is standard but we're amenable to negotiation, because things change. The contracts that we do have in place at the moment and the ones that I've seen from major record labels, that I've seen from some distributors, that I've seen even from the artist managers, are very archaic and they're old. They are based on old provisions. They are not moving with the times. So from a standard operating procedures perspective, I can say that the clauses are standard, but not the actual practice that is implemented in this day and era. So without limiting, the ability to still freely contract and not over-regulating or legislating, I think yes, some sort of practical operating procedures do have an advantage and they do have a place. So, and as we get into it, the laws are already in place. There are laws there. The question then becomes the issue around the role players. Are they aware of the laws and how to apply and implement those laws, whether in their favor or not in their favor? And unfortunately for the creatives or the artists in this instance is that the record labels or the music executives know what the laws are and they apply them to work in their favor. The disadvantage for the artists is that the artists don't know the laws, therefore they can't apply the laws because you don't know what to look out for. If you look at contracts, pretty much the clauses and the provisions that would be in that contract, they are saying the right things to protect themselves as the label. They are giving themselves the rights as is envisaged in the legislation, but because the artists don't understand what it means and what those contracts say, they end up putting themselves in compromising positions where they sign away the rights that have been granted to them by the copyright legislation or any other legislation. Tando spoke about competition. There's competition laws. Those competition laws don't limit who they apply to. They apply to anybody in business, and artists are in business. And I think that's also the key takeaway, is that most artists don't consider themselves as a business. You just think, I'm just a creative and I'm just making music. No, you are not just. What you are making is what is actually driving economies. It's why we're here right now, is because the music industry does have money, it does have revenue, it generates a tremendous amount of revenue, especially in South Africa. So my practical conclusion is that an industry works when it works together. So if the industry is not working together, it will not work. Because one, the labor laws are there, but the labor laws do not apply to artists for the greater part because you're not considered an employee, and that is how those contracts are structured. Whether an artist would want to be considered an employee is something that I would possibly say it's better off for you to work as an independent instead of an employee, because when you do work as an employee, everything that you create under the banner of I'm an employee and this is a labor-related issue, means that the music that you're creating it solely for the person that you work for. So if you work for a company, I'll use the Please Call Me example. A huge example of somebody creating something, it was their own intellectual property because they worked for Vodacom. Vodacom then made the allegation that it owns the idea of Please Call Me. And this is because, practice has also determined that whatever you do under the course and scope of your employment means that it is done for that particular entity. So in terms of, with the music industry, the difference here is that the actual creatives and the artists sign away that right that they have from the onset, whether you're signing it in perpetuity, because some contracts that I've seen would say that, I'll use the license agreement that I recently saw. The license agreement was that it's for a 3-year term that, they would release, they'll distribute, they'll do all the labor required services on behalf of this particular artist, and they would also then give them a lump sum, a sign-on fee in the beginning for purposes of licensing this particular album exclusively. It was actually a couple of album deals exclusively under this label. But what it then says, in terms of the rights that are being granted, the rights that are being granted are now granted in perpetuity. And then it says, and for the life of copyright. So now what it's saying is that forever and a day, this label is, as much as the contract is only for maybe 3 albums or the license period is only for 3 years, then the rights that the label will have will run over in perpetuity over and above that 3-year term. And that says to me that that's already creating a conflict between the term and the term of the actual contract and the life of that copyright in that, because what it means is that if I want to go and contract using this material that I have after the 3-year period has lapsed, I, in essence, can't do that because they've got that right, and depending on how you've negotiated it, they've got that right in perpetuity and exclusively. So that already is a conflict, it's a contradiction, and is subject to, court proceedings and, and litigation. Okay. Sorry, I'm losing my notes, okay? Correct. And then in terms of contract management, I mean, contract management is not necessarily such a huge issue in that, if I've got a contract, I just need to know what my terms are. I need to make sure that I do have access to it. So it's not really a problem in the greater sense of the industry. It's only a problem if you don't know where your contract is. So it's really, I don't think it needs much because there are already contract management, software services, etc., that are available that you can get. And I think from an artist's point of view, it wouldn't really be applicable to the artist because you're in essence, you're not really signing 1,000 contracts at any given point in time. So it would be more applicable from a label perspective for them to have, standard procedures, but those can then be applied in accordance with ordinary contract management services that are available. Okay. Right. So, I mean, I think I've already touched on the issue around the standard operating practices and that, the standardness, the standardization is only insofar as the labels would say this contract is standard, or the managers would say this is a contract that I use which is standard and applies to everybody else. And the only changes that have been made to these particular contracts would always come in the sense of from a brand ownership or live events, So taking a recording deal that was just, linear in terms of recording and releasing the music to now becoming a 360 deal, which then incorporates, taking revenue from all various income streams to the extent that now some of them even take revenue from the brand in the sense of doing influencer work that is not necessarily related to the release of the music, but the argument then becomes, well, we've built this brand that is, the artist that that had we not built this brand, then this artist wouldn't have the opportunity to get a deal from, a KFC or Chicken Licken, and the only way they're doing it is because of the brand that the label has developed. And, and I think the biggest issue with the standard nature of how the recording industry works and the music industry is that sometimes the provisions are so onerous on the artists that they do not have some sort of favor towards to the label instead of having favor towards the artist, and actually creating a fair, platform that parties earn. And obviously with whatever you're agreeing to, there's going to be sides where you have to concede, and there's going to be areas where you must stand your ground. And I think the issue is that the music industry is probably the only one where it thrives on exploitation, and the exploitation is normalized and is seen as standard, which is a problem. And even with these particular contracts that I'm talking about, is that they don't take into account new developments. I mean, there's blockchain, Web3, there's AI, there's NFTs, there's all these new developments that the contracts don't necessarily take into account. They just slot in words that make sense as they come up, instead of looking at this contract globally and seeing how we are universally, where we are in terms of music industry, how are people releasing, are they still releasing in the same way that they used to release music? Does it make sense for us to contract the way we contracted even 5 years ago? And the answer normally comes as a no, because the music industry has changed. A lot of artists still want to release independently. However, even with that comes with its own beasts and its own disputes, as we've seen, where independent artists and the people they release under, there's stories around theft, etc., etc. And I just think, from a standardizing point of view, and I'll use this example, the engineering and construction industry, they've got what they call the FIDEC conditions of contracts. So they're known as the red book, the blue book, the yellow book, etc. And these books set out the standard terms that you would find in these type of engineering and contract and construction contracts. So what that does is that industry has come together to put together and codify certain provisions that they think in any sort of contract, what would we need in order for us to do business? What that means is that they have come together, be it the actual engineers themselves who are in this industry and the consumer of the service. And they've put together these particular documents, which they then refer to. So, as maybe as impractical as that might seem, and that's why I said I might upset the lawyers, is that when you've actually created something like that, then the two bodies, whether it's the creatives and the music industry executives, they know what the basis of contracting is. In terms of the commercials, then you can have discussions around the commercials. Then you can have discussions around how long, what's the duration of the contract. But if you've got certain provisions that are lock, stock, and you know how these provisions work and what they mean, then you don't always need to have legal intervention unless there's a massive deviation from the agreements, or you just want to make sure that there aren't any conflicting provisions and you want a lawyer to look over it, or you decide to do this. If there's a dispute, then you would need, legal intervention. But if there's some sort of codification and working together as the artist and the executives to actually create these kind of things, then it leaves us out of the system, because the argument is always that we as service providers of the entertainment industry are always expensive and are pricey. But litigating is more expensive than actually having a 1-hour consultation at the end of the day. But in order for this to happen, there has to be that joint effort from both the executive branch and the creatives themselves. The music industry must come together, like the television and film industry, where producers cannot talk directly to the actors. They always have to go through the agent in order to have any sort of conversation with the artist. So if there's and that was done because the industry came together. They made these decisions, so it eliminates issues of either exploitation, deviation of contractual terms without the parties' representatives being there, and also creating a system that is workable for all involved. And yes, it might seem impractical when you're sitting in studio trying to record and there's a deviation and you have to phone an agent or a manager, but that the system is working and it actually regulates it and prevents a lot of issues from happening in the long run. And I think another issue is that from an education and a knowledge transfer perspective is that the artists are not educated enough. they themselves don't equip themselves with enough information to know what it means when, when you're signing away your rights, to know what it means, the difference between licensing and the difference between knowing what a distributor does and what a publisher does, and knowing that SAMRO is not a catch-all for all collective management organizations, that there's different CMOs that exist and they do different things. So the issue then becomes also a knowledge base, because the information is there, but the creatives themselves are not taking time out to get the information and know what they're dealing with. So in general and in closing, I think the whole value chain must treat the industry like a business, including knowledge, the contract management, and skill development. The artists need to actively participate in the industry. Yeah, and if one flourishes, then I think the value chain would also flourish in general. Thank you.